Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in live from our San Diego office. Please join me today in welcoming Senior Attorney Maureen Scorese from our Edison, New Jersey office. Hi there, Maureen, and welcome. Thank you for being here, Maureen. So for today's topic, we're going to be discussing the U.S. Department of Labor's latest development, specifically the new independent contractor classification rule under the Fair Labor Standards Act. Just a quick disclaimer before we get started, we are live on LinkedIn and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions on this topic, please email us at info@chug.com so we can help you out. Now let's get right into it, Maureen. Can you share with us what is the new DOL Independent Contractor Rule 2024?
So the new rule is entitled Employee or Independent Contractor Classification under the Fair Labor Standards Act. And this rule was revised from their previous guidance on how to analyze who is an employee versus who qualifies as an independent contractor under the Fair Labor Standards Act. This final rule rescinds what was previously implemented in 2021, and it replaces that rule with an entirely new analysis for how to determine if a worker is an employee or an independent contractor.
Wonderful. That's a great summary about the new rule. So when does this new DOL Independent Contractor Rule become effective?
So it takes effect on March 11th, 2024. So just about a month away.
Great. So it's coming up. And regarding this, what are the factors to consider under this 2024 rule?
So the final rule continues to affirm that a worker is not an independent contractor if they are economically dependent on an employer for work. How that's defined or analyzed has changed. So the fact, and this is what we'll get into throughout the talk. The 6 factors that are now part of the analysis of whether a worker is an employee or an independent contractor under the FLSA are as follows. They have an opportunity for profit or loss depending on their managerial skill. The worker there's investments by the worker and the potential employer. The degree of permanence of the work relationship, the nature and degree of control in the work, as well as the extent to which the work performed is an integral part of the potential employer's business, and the skill and initiative of the worker. So these are 6 factors that are actually quite complex. And neither of them is more important than another. It will really just depend on sometimes the factual circumstances of the arrangement, the work relationship. And there could be other factors that come into play depending on the work.
Wow, those are really some factors to consider for this. So in comparison with the previous rule, what changes have been made to this new rule?
So the previous rule was much more narrow. It was the 2021 independent contractor rule was a narrow economic reality test. The facts were limited as to what would be considered part of the test and what would be relevant to determine whether or not the worker is economically dependent on the employer for work or has their own business separate from that employer and hence an independent contractor. So that 2021 independent contractor rule was a variation from the prior judicial precedents of independent contractor rules. So previously it was much more a multi-factor economic reality test and a totality of circumstances test, which is a bunch of legal jargon that really says there's a lot of factors that the courts and the laws would look at. And the 2021 rule narrowed that. So now we're back to a broader definition of and analysis for how to determine if someone is in fact an independent contractor or a worker.
Great. So it sounds like there are a lot of things to look at with this. Can you discuss how this new rule impacts businesses and employers specifically?
Sure. So the Department of Labor issued this rule with the intent to provide detailed guidance on employee versus independent contractor status that would be consistent with FLSA, as well as the precedents prior to 2021 that was interpreting the FLSA. So in this way, it would make it easier for employers to understand who is an employee versus who is an independent contractor. It also helps them allegedly to be in compliance with other laws as well. But it does require a new review of independent contractors that may currently be on in relationship with employers. So it will require some new audits and reviews of agreements.
Wow, so it sounds like we really need to look into this new rule. Can you touch on what legal challenges, if any, are anticipated against this new DOL independent contractor rule, and how might these legal challenges, if there are any, affect its implementation?
So there are legal challenges anticipated. There are legal challenges initiated by editors and freelancers who oftentimes are in these relationships with the same employer. And so they may now fall under the category of an employee, and they don't want to because they want their independence to still be able to freelance, to still go to other sources for work, in spite of the fact that a large part of their work may be repetitive with the same business relationships, right? As far as their workflow. So it will create challenges for those who want to maintain independent contractor status, but the new rule now is going to make them be qualified as an employee. And the problem with that is because you can't waive your status. If you're an employee under the rule, you're an employee. You can't contract that away. So it does make it more difficult for those individuals that want to maintain independent contractor status.
Wow, that's a lot to take in. So it does seem like we're going to see a lot of changes because of this new rule, and we'll have to see what comes from this. So how might the new rule affect contract negotiations between employers and workers who are classified as independent contractors?
So the factors that I mentioned earlier will definitely require more details in those contracts between independent contractors and their employers or the party that they're contracting with for work. They're not employers, just another the company that contracts with them. So it requires a lot more detail to be put into those contract negotiations if the individuals want to maintain their independent contractor status. It will, if they want to become an employee, it'll be much easier for them to now be an employee because the rule has made it much broader in terms of how to define an employee versus an independent contractor.
Those are some really important things to consider. So I know we have a lot of employers as our clients and who watch our lives. So what are the most important steps that employers should be taking to ensure compliance with this new rule?
So first, the best thing I can always stress here is it's really best to seek independent legal advice for your particular situation. Employment has a myriad of different laws that are impacted and affect your decisions, and whether you are in compliance. So you need to look at not just this guidance as far as independent contractor rule for application of the FLSA, but you have to also look at IRS requirements for what is defined as what is an independent contractor. You also have to look at your state laws. There are a handful of state laws that have a more stringent test. It's often referred to as the ABC test, but this is one that is actually more different, and it's different from this new DOL guidance that we have on independent contractor rule. So you need to look at a number of different laws to ensure compliance, not just with the independent contractor rule, but these other laws as well.
Wow, that's great advice. So if you guys are watching this, make sure you are checking with your attorneys. If you do have questions about this process, there are quite a few changes, as Maureen has mentioned. So do check with your attorneys to make sure you guys are staying compliant. And just a quick disclaimer for everyone watching, we are live on LinkedIn and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please email us at info@trig.com so we can connect you to Maureen. So Maureen, let's get back into this. So how do we classify an employee with the new DOL independent contractor rule? Can you discuss that a little bit?
Sure. So with that rule, you want to look at the different factors that I mentioned earlier. And so you have to determine, that first factor, the opportunity for profit or loss, depending on the managerial skill, right? You want to, that person, if they want to be an independent contractor, have to figure out, are they in control of their jobs, based on their managerial skill? Are their jobs fixed at, if the work is being paid at a fixed rate, it make them qualified as an employee. If it varies based on their performance and their managerial input and skill, then they'd be more likely an independent contractor. The investment by the worker and the potential employer are both parties contributing and investing in the work relationship. Is that worker making a capital purchase for his own office that goes on his line item, his budget? Or is the employer buying him supplies or giving him, reimbursing him or her for investments? So you want to see what kind of, and it's not just, the size, it's not just the size of the investment, but it's really just, are you making an investment and where is that investment going? To determine whether or not there's true independence for the independent contractor or they're really an employee. Another factor you look at is the permanence, the degree of permanence of the work relationship. Is it just temporary? Is it continuous? Is it indefinite? Similar to an at-will relationship. If it is, then that person, if it's an indefinite relationship, they'll be considered an employee. Otherwise, if it's just for project-based or specific in duration or sporadic, then they would be considered more likely to be considered an independent contractor. So again, the fourth factor that was in the new rule is the nature and degree of control. So you have to look at who's in control of the work. And it's not just on the employer side. You don't just look at whether the employer is controlling compliance issues, right? It's really the control of the project. And if there's who's in charge of what's going on in the workers' work versus how much the employer is controlling that and giving direction as far as where the work goes. And then the fifth factor talks about the extent to which the work performed is an integral part of the employer's business, or is that independent contractor running their own business and it's separate from what the employer is doing, right? So they're truly an independent contractor. And one way to look at this is where you have a consultant who has a specialized field that employer's business doesn't have. So that's obviously that independent contractor or consultant is adding to the employer's business and they're separate. And then you also need to look at that sixth factor, which is the skill and the initiative of that worker. And whether that shows that they're on their own, an independent contractor taking their own initiative for their own business, or if in fact they're relying more so on the initiative and direction of the employer, which somewhat would overlap with that factor 4 and the degree or nature of control.
Those are so many details we need to look into for this employee classification. I appreciate you covering all of those in detail and sharing with us, what employers really need to know to see if their employee is classified as an employee or technically as an independent contractor. So regarding all of the stuff that you just mentioned about independent contractors, how does this new rule affect worker rights and protections? Does it affect them? What do we have to know about this?
So for workers' rights and protections, the The classification, the new rule classifies more people. It's easier to classify a worker as an employee. And in that way, it gives those workers more protections from federal and state laws that would protect their minimum wage, overtime pay. Oftentimes an employer might set up situations for independent contractors to avoid overtime pay. Um, and there's lots, and just work environment. There's a lot of protections that employees are entitled to that independent contractors don't have. Similarly, there would also be on the employer side, which is also a benefit and protection for the employee, would be unemployment compensation, workers' compensation. There's the insurance, other benefits, and so there's more for those employees. There's more protections for them in that situation.
That's really good to know. So one of the most common questions we're getting from businesses are how should they update their contracts or policies to comply with this new rule? Do you have any advice for business owners on what they should do, how they should update their contracts or policies to comply with this new rule?
So it's going to be very specific for those businesses, but I would refer them to their agreements. If they are working with independent contractors, go back, look at your relationship and how you interact. Look at what the agreement says, because oftentimes relationships change after you sign the document. If it's supposed to be maintained as an independent contractor, in business relation, employer relation, and not an employer relationship, then you need to go through and fine tune that agreement, perhaps with an amendment. And it may turn out when you're reviewing it that that independent contractor becomes an employee, because that's what the relationship has become fluid and evolved into, and that's what makes sense. But you definitely need to review your contracts and your policies, your employment policies as well, to adjust for this new rule.
That's really great information. Thank you for sharing that with us. So how does this new rule address the gig economy and digital platforms, which rely heavily on independent contractors? I know this is, a huge thing that's consistently growing, and, we need to address this. So is there any information on this?
So the new rule seems to most likely help those individuals in the gig economy become an employee, get that status as an employee. There's been a lot in the news over the past few years, especially after COVID, where the gig economy really thrived. That made it seem that work conditions for those independent contractors was really poor. It was really terrible for them. And so this particular rule doesn't address the gig economy or digital platforms specifically. However, the definitions and the guidance from the Department of Labor, it does in fact would include more of those independent contractors to now be an employee. And that would be very beneficial to them. It also helps bring more equity to the population as a whole, because a lot of the people who end up being gig workers are oftentimes minorities or just immigrants and things like that, people who don't easily get employment, and are these will protect them for those gig workers.
That's great news. So this sounds like good news. If you are an independent contractor watching this, this is a great rule for you, and definitely look into this and know your rights. And if you have questions, please reach out to us anytime. We would love to help you out with this. One more question, Maureen. Thank you so much. I know you're short on time, and I appreciate you answering all of these questions for us. So what are the penalties for misclassification under the new rule, and how does this compare to previous standards? Can you touch on that for us?
So I can tell you that the misclassification of employees will be a huge problem and a liability for the employers. So there are your employees can file lawsuits, and you'll be exposed to more litigations. The government may crack down and there'll be penalties, for example, under the Affordable Care Act. If you're not including all your employees, which you now have to reassess under this new rule, who is an employee and who is not, you'll be exposed to penalties if you're not including people properly under these other laws. And so it's not just the new rule, but it's a myriad of other federal and state laws that you now have to look at for compliance. So be careful and seek your legal advice to be on top of these new independent contractors versus employee situations.
Thank you so much for those words of wisdom, Maureen. We truly appreciate you for taking the time to break this down for us and answer everybody's pressing questions on this topic. If we didn't get to your questions, apologies. Please email us at info@chuk.com and we'll be sure to answer your questions and help you out however we can. This does bring us to the end of our conversation. Thank you so much, everyone, for joining us today. Please like this video if it was helpful, and to stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube, all the social medias. If you guys have any questions or suggestions, please send us an email anytime at info@chuk.com. We would love to help you out, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you for joining us, and a special thank you to you, Maureen. Thank you for taking the time.